Yes, Mr. Sachdeva.
My Lord,
I will probably ask you, incidentally, to finish just before 3:45.
Yes. No,
which will take on board the 2.5 extra minutes you've got into the short adjournment and give your opponent some recompense for the problems of the morning.
I'll of course do that, my Lord. Thank you. I had just one more preliminary comment to make, and that was the rhetorical question, why is there a separate category of capacity in relation to sexual relations? Why couldn't it have been dealt with under contact? Well, there are two answers. First of all, the specific reference to sexual relations in section 27 of the Act. And secondly, the historical development that you've seen that the courts have chosen to identify a separate category of capacity to consent to sexual relations. Otherwise, in another legal system, in another galaxy far, far away, you might want to deal with these issues as part of contact, because you could certainly see sexual relations as an element of contact. Certainly, sexual relations require contact, and the current system, and I'll come on to that, creates the very real possibility that someone can have capacity for sexual relations but not for contact. And working out how that works on the ground is tortuous, to say the least. I think my Lord Stevens also expressed surprise that one could have capacity to marry but not have capacity to have contact with the person one has married. That is the difficulty when you have tests that are set at different thresholds, and some tests don't allow you to look at the identity of the counterparty. So, turning to the background facts, can I take my lords and my ladies to the Court of Appeal judgment, which you'll find, I think, at, is it 220? I think it starts at 218. And you'll see the court first comments on three fundamental principles, paragraph 3 of public interest, the principle of autonomy, paragraph 4, the principle that vulnerable people in society must be protected, paragraph 5, and then paragraph 6, a third principle, that the Mental Capacity Act and the Code of Protection do not exist in a vacuum. They're part of a wider system of law and justice. Sexual relations between two people can only take place with the full and ongoing consent of both parties, and that the principle has been more widely recognised in recent years, I add in parenthesis, with the Me Too movement and various extremely contemporary changes in understanding of the relationships between the sexes, and of all things, even if 20 years ago it might have been possible to say that this isn't a consideration that needs to go into a law about how P makes decisions about what to do, that certainly can't be said now.
The expression consent to sexual relations does imply a certain dominant partner.
Possibly, yes.
And the
protagonist.
The word engagement is more gender neutral.
Indeed, and more reflective of reality.
Yes, different types of relationships.
My ladies and my lords will remember in 1991, before that, there was no offence of rape within marriage. And it took a court, the House of Lords, to overrule that by an interesting process of statutory construction. But that's what happens. Quinta Vale, which is in the bundle, is all about how a statute is always speaking and how it reflects contemporary understandings of societal values. And in 2021, it is impossible to conceive that a highly relevant factor between capacitous people would not be whether the other person is able to consent. They look over 16. You don't have to get it right. They're apparently able to consent, and that they are apparently consenting, which is comprehensible, workable. It's not hard to understand, and capacitated people do operate that very recognition whenever they consider having sexual relations. And to that extent, the judges are right under the inherent jurisdiction that this isn't a complex concept. But the answer in this case is paragraph 100, subsection 2, reflected in Lord Justice Baker's description at 106, is not a difficult concept either.
But it is part of your submission that we need to apply an always speaking...
You don't need to. No. I'm saying that even if I was wrong about everything else, I mean, the reason it hasn't... I think that the point has been hinted at by the other side because it's not been found to be part of the relevant information in any other case. It's been doubted obiter in a couple of earlier cases, but it's never been actually raised squarely as the difference between someone having capacity and not in any case.
No, but I think what I'm asking you is, are we meant to be looking back at attitudes when the Mental Capacity Act was passed in 2005, or are we looking at attitudes as of today?
You are construing the statute to the extent that it's needed, and I say it isn't needed because I think that my submission is that if this issue had arisen in October 2007 when the Act was first passed, the same answer would have resulted.
Okay.
There hasn't been
if it had been passed in 1992, your answer would be different.
I don't think it would have. It wouldn't have been, but it wouldn't have been that as clear. No.
But aren't you looking at the decision that is being taken?
Yes.
And the decision is today.
It's today. It's a forward-looking test. So I'm only mentioning the always speaking point because it has been hinted, but not said out loud, that this would be in some way a departure from the previous law. But it's not actually been litigated in any other case in a way that mattered before. So I think we were at paragraph 6, and then we have the background facts, which I know that your ladyships and your lordships have read already. Can I ask that particular attention is paid to paragraphs 11 and 12 and 14? And the particular problem with consent is that he doesn't think that a woman can change her mind. That's the particular problem with consent.
Is this changing of the mind? Is this that he doesn't understand that she might be happy to be a bit flirty and kiss and cuddle, but not actually want to engage in full sex? Or are we talking about engaging in full sex and her changing her mind partway through?
I think it's the latter, my lady, that they're not allowed to. The rules of the game are such that he's then allowed to carry on. He doesn't accept the contrary proposition.
Well, I think if they'd had sex with somebody else and they knew that.
I beg your pardon, my lady?
And the rules of the game would also produce that result if he knew that that person had had sex with someone else.
Indeed. There was also reference to if someone's had sex at a party with someone, they're then open to whoever. And that's the basis for Dr. Thrift concluding that if unsupported in the community, there would be a high risk he'd commit a sexual assault in pursuit of a sexual relationship. And that also includes the risk of criminal offences. I'll come back to a few additions to the facts that I won't read out, but I'll refer your ladyships and your lordships to. So then the Court of Appeal set out the law, statute, and then go through at length the case law, and that is, I won't go through the case law because the Court of Appeal accepted exactly my submissions on the case law, so they recorded them here, and that's 25 through to 75 on the cases. All I would point out in relation to the cases is that you'll see that the reference to D and AB, which is 37 and 38, at 37, the holding was that P lacked capacity in relation to sexual relations, third line of paragraph 37. So when Mr. Justice Mostyn finds that to import, and this is essentially the same points as before this court, 2 and 3, if you look at paragraph 38, about 6 lines down, that only adults over the age of 16 should do it, and they should be able to distinguish, and that both or all parties need to consent to it. When he rejects it, that's obiter. And then if you look at paragraph 54, that's the other case in which this issue has arisen, the KA case, and that's Mrs. Justice Parker, paragraph internal 54, that's EF 235. At 54, she says she's less certain that consent of the other party's fundamental capacity But the reasoning is somewhat unsatisfactory. Since it's all too possible for sexual contact to take place and does take place without consent, the necessity for the consent of the partner doesn't obviously form part of the capacity test, but I need to consider these questions. So it's again, obiter. I mean, just because non-consensual sex takes place does not, it's completely, I mean, it actually goes the other way in terms of whether it's desirable as a matter of public policy for knowledge that the other person must be able to consent and is consenting throughout to be part of the relevant information. So then the submissions to the court are summarised at 91. We get to the discussion and conclusion. And the court approves the observation in the PC in York case, which I'll come to, which essentially says the way you look at the statute is decision specific. You look at a decision and then you ask what the information relevant to the decision is. And it's unhelpful, Lord Justice McFarlane says, to start dividing, to use concepts such as act-specific and person-specific, in fact, because you're just applying the statute. And what act-specific really has been used to do is to limit the relevant information to a decision so that you can't take account of the identity of the other person if in an act involving two people. And you won't find any support for that in the Act. And I'll come to my submissions on person-specific. But really, my submission is the court should simply apply the statute without glossing it with words that supposedly lower the threshold for a decision in particular areas which are thought to be somehow closer to primal instincts. And we'll cover all these points. So the Court of Appeal at 92 say, first of all, they discuss the engage point. I won't go over that. And that's at 92 to 93. And at 94, the court says, when the decision is expressed in these terms, it becomes clear the information relevant to the decision inevitably includes the fact that any person with whom P engages in sexual activity must be able to engage in to such activity and does in fact consent to it. All I would say there is that conclusion isn't dependent on whether you frame the decision as engagement with sexual relations or consenting to sexual relations, as long as consent is understood both where you're the recipient of an offer and where you're initiating the offer yourself. But this is where the Court of Appeal get it absolutely right. We say sexual relations between human beings are mutually consensual. It's one of the many features that make us unique. A person who does not understand that sexual relations must only take place when and only for as long as the other person is consenting is unable to understand a fundamental part of the information relevant to the decision whether or not to engage in such relations. Then Lord Justice Baker deals with...
Does that run the risk of meaning that every rapist runs a risk of lack of capacity?
No, because rapists understand.
Oh, I see. They understand but ignore.
Well, they choose not to follow it.
Yeah, I mean,
and that's the key distinction between a rapist and somebody like JB, and that's why he wouldn't, in reality. The criminal justice system is unlikely to find that he had the mens rea, because, as we'll come to it, relevant characteristics, including an inability to understand or to recognise consent, is a relevant factor in whether someone has a reasonable belief defence. And there was an incident in 2016, and the police didn't pursue it. And the court can't draw any inferences about the reasons for it. We don't have the facts. But you can see that, contrary to the suggestion that it's all a matter of the criminal justice system, first of all, the criminal justice system won't deal with this. And secondly, this is in the name of the least restrictive option for someone like JB, is it? Is it really least restrictive to throw him to the mercies of the tender mercies of the criminal justice system? And I'll take the court to what will happen if he is incarcerated in a mental health hospital. Dr. Thrift says it will be catastrophic if he is incarcerated for any reason to his own mental health. And one can see why. He has enough difficulties dealing with the world with one-to-one supervision, being able to go out when he wants to go out under supervision, if he's incarcerated in a cell, what will that do to his mental state? And that's really the other side of the story. We can talk about his being held back from pursuing interest in women, taking it to a normal level that people in society aspire to, and that's apparently very harsh. But actually, what's the alternative? Pending the education. Because this is only an interim position that we're talking about. So, I think we were at 95.
The Court of Appeal use the word capacity in paragraph 100, subparagraph 2.
My lord, yes.
And they use the word able in paragraph 94. Is the word able better?
Able is better. This is not a capacity assessment.
Yeah.
You don't have to. That's an expert report commissioned by all the psychiatrists with various requirements. We're not saying that you need to be able to do a capacity assessment.
Yeah.
Do they apparently look of age? And are they not obviously incapacitated? I know that sounds like pushing the argument back to you, but are they unconscious? Are they so intoxicated they can't even speak, for instance?
That's not been the problem. The problem is his approaching vulnerable women who themselves may not have capacity.
Indeed.
But you might say, well, they presumably got their own people looking after them. I'm not quite sure how.
Yes.
Does he need to be able to see that somebody he's approaching might have the same sort of vulnerabilities as he has?
So the hardcore answer would be yes, but actually the realistic answer is that sometimes when you meet a new person, it's not that clear whether they have capacity or not. And if there's ambiguity, then it can't be held against someone who isn't a specialist and doesn't do capacity assessment. So unless there's a reason to think that somebody who is of age might lack capacity, and there will be some cases where somebody can't speak at all, for instance, or they're just looking around the room and not connected to anything. But these are the most obvious cases, and that's why the test is workable, because we're not talking about a nuanced capacity assessment, asking the relevant information of the other person and seeing if they properly comprehend the answer. We're not talking about anything like that.
I mean, Glanville Williams makes this point about the tests mustn't be placed
Indeed.
in such a way that people who happen to have lower intelligence can't indulge in sex.
Absolutely. Absolutely. And there's very good public policy reasons for not being overcritical.
Right.
But this is, there are a number of cases, and there have been too many authorities cited to this court, for which I apologise. But there's a case called PH in 2011 in which Mr. Justice Baker says you have to be careful not to set tests too high in general because it's unfair. And then there's another case called, I think, LBL, where it's said that only the salient points need to be understood, not every detail. And that all goes to the same point, that it mustn't be unrealistically demanding, this test. But that doesn't mean that the test shouldn't exist at all.
I mean, that seems to me a very significant point, if I might say so, that you would actually remove in 100 subsection 2, or sorry, replace.
Yes, it's 106, I think, that we rely on in particular.
102, so it would just read the fact that the other person must be able to consent.
Yes.
And you say that that gives a steer that this is not a sophisticated, legalistic type of question. It's actually a pretty rudimentary, basic approach that's required.
An ordinary assessment that a person in the street might be expected to exercise without any technical knowledge. Then the court is going on to discuss the criticism that obviously there has been some description of the sexual act as being largely visceral rather than cerebral. And at 96, Lord Justice Baker deals with the point by stating that Citing earlier decisions, including, it must be said, Sir Brian Levison's decision in REM, that said the decision is largely visceral rather than cerebral, owing more to instinct and emotion than to analysis. But the court said it's never been suggested that decisions are exclusively visceral or instinctive. It is, of course, true that sexual desire is emotional rather than intellectual, but for human beings, the decision whether or not to engage in sexual relations obviously includes a cerebral element. It involves thought as well as instinct, and amongst the matters which every person engaging in sexual relations must think about is whether the other person is consenting. And the other point to be made is Lady Rose's point, which is to do with how then is the risk of pregnancy and STDs to be characterised as a visceral decision. We've already let in, the appellant concedes these other points are perfectly legitimately part of the test, and there can't be any qualitative difference between those assessments and the point being made in this appeal. The point is also made that the focus, this is 97, of the MCA is different from that of the criminal law. But Lord Justice Baker says it would be wrong and unprincipled to exclude an understanding, and this is the consistency with legal policy in the criminal sphere point, to exclude an understanding of the consensuality of sexual relations from the relevant information on the grounds that non-consensual sexual acts should be dealt with by the criminal justice system. And the judge says the criminal justice system doesn't necessarily deal with such cases, as illustrated by the history in this case. But even if it could be guaranteed that such incidents could be dealt with by the criminal courts, and I think this is Lord Stephen's point, to leave such matters to the criminal justice system would be an abdication of the fundamental responsibilities of the Court of Protection, which include the duty to protect P from harm. And I say that the matter of, and I'll come to my submissions on that, statutory construction for a start. There's nothing excluding public protection from the MCA as a legitimate objective of the MCA, plus the very clear human rights angle, Lady Arden's point, that we have positive protective duties in Article 8 and Article 3, and how we, as a state, carry those duties out is within the margin of appreciation. So if the Court of Protection perfectly rationally were to play a part in dealing with the very difficult problems out there of people who generally don't understand the contours of the criminal law, surely it's better to allow them to protect both P and the population before a crime occurs, rather than to leave it to the criminal justice system to perhaps sort out once the damage is done. But that's the point that the court makes. It would be an abdication of the fundamental responsibilities of the Court of Protection to fail to protect P from harm. And then the court says it's not discriminatory because it's a restriction, this is 98, which applies to everybody regardless of whether they have capacity or not. And it's well recognised in the European Convention. Article 8 rights are not absolute and must be balanced against other interests, including the rights of others. And that's the short answer to the Article 8 claim. I would add another part to it. It's actually against the infringement, the interference with his Article 8 rights are his own Article 8 rights to be protected from harm, from the consequences of his action, and also the rights of others, the Article 3 and 8 rights of others. So obviously a rape can certainly reach the standard of Article 3, and there is a duty to protect potential victims of non-consensual sexual activity, and Article 8 is a qualified right and would readily bow to an absolute right such as Article 3. So then the court summarises the relevant information, and then, as I say, at 106 is the formulation that we would support, that you should only have sex with someone who's able to consent and gives and maintains consent throughout. And that is very similar to the guidance given to school children. I think we've I've asked that the guidance that school children are given at the age of 16 be emailed to the court. And that's in similar, everyday, comprehensible terms about consent and sexual relations. So that's the Court of Appeal judgment. There's only one more point in it. They do shy away from the tailoring point, which is at 101 to 103, based on it not arising in this case, because the consent point is not something that can be tailored out of the test. But I will make some submissions on that, and that I think arises out of the NB case, where Mr. Justice Hayden suggested that the risk of STDs in a long-standing marriage could be tailored away by a judge in an appropriate case, so that that wouldn't be the reason why the woman would fail the test of capacity. But I'll make some submissions on that. There is just one other addition to the facts, if I may, and that's at EF 127 to 130, which is in the written case. Those are more detailed references to Dr. Thrift's report, which, as I say, I won't read out, but they're there if you find it helpful. Now, moving on to the first theme, construction under the Act, whether the consent of the other person is relevant information under the Mental Capacity Act. Now, can I commend to you, in relation to the pre-MCA capacity law and the background to the MCA and the Sexual Offences Act, my juniors have done what appears to be quite a learned appendix to the skeleton. You will find that in the additional documents. It's EF 4520. And that gives you some background to the MCA from paragraph 3 onwards. That's at 4520.
In fact, if you say this appears to be learned, I'm assuming you really mean to say it jolly well is learned.
Well, I mean, in my humble opinion it is, but it's not really up to me, I think. I mean, no, it looks pretty good to me, to be honest.
Okay. I just wanted to be sure you weren't casting any gentle aspersions.
No, I wouldn't dare. Certainly one of my juniors will, not have good things to say to me. I think you can guess who. Paragraph 10, 4524, is just one sentence I'd like to take court to, and that is the Law Commission's report. So a lot of this obviously came out of the sterling work done by the Law Commission in the 90s. And the preliminary consultation paper, in that the Law Commission noted that, as with marriage, sexual intercourse must be a matter of a personal choice by the individual, so that if he or she is incapable of making the decision, no one may make it for him. And that's what led to Section 27. It's the personal nature of the decision.
So would you accept then that whether the decision is to engage in or to consent to, Section 27 must take that out of the...
Yes, that's the intention. So it's semantics, whether you use... Engaged might more readily reflect the reality in terms of language, but because the word consent is used in the statute, when we say engage, we mean consent in Section 27. So you can ask yourself, what's the point in having two terms when they mean the same thing? But I think the bottom line is it doesn't affect the relevant information. The relevant information is still, the consent point still goes in. So the key question is the proper construction of the Mental Capacity Act, and you therefore have to examine the Act itself. And we can pick that up at EF 859. It's the core authorities. So Section 1, following principles apply. This is page 859. For the purposes of the Act, there's a presumption of capacity in subsection 2. Subsection 3, there is an obligation to take all practicable steps to help someone make a decision before you can treat someone as being unable to make a decision. And someone doesn't lack capacity merely because they make an unwise decision, subsection 4. And at 6, before the act is done or a decision is made, there's reference to the least restrictive outcome. Then we turn not to section 2 but to section 3 first, which is at 861, and this is what Lord Justice McFarlane tells us in the City of York case at EF 2925. Because if you look at 2 first and then 3, you get a much wider group of people falling into the category of incapacity. So you look at the functional inability first, and then you see if it has a diagnostic label or not. So inability to make decisions, the purpose of section 2, a person is unable to make a decision for himself if he's unable to understand, retain, use or weigh the information relevant to the decision. And at subsection 4, the information relevant to the decision, it's a partial definition, includes information about reasonably foreseeable consequences. So you first ask yourself, does the impairment or disturbance render the person unable to make the decision? Then you go to section 2 and ask yourself, is that impairment because of an impairment or disturbance in the functioning of impairment or a disturbance in the functioning of the mind or brain? So if we now look at section 3.4, the information relevant to a decision is set out in section 3.4. And the first observation to make is that it's a partial definition. It doesn't purport to be exhaustive. It's inclusive. It tells you what it includes. It doesn't tell you the rest of it. But it clearly must include the basic characteristics of the physical act, the nature and character of the act. And the earlier cases, the inherent jurisdiction cases such as MB and MM, focused on this element of the test, but did also recognise the foreseeable consequences part, but without making a reference to the Mental Capacity Act, which wasn't in force at the time. So the reasonably foreseeable consequences are of deciding one way or another, of failing to make the decision. And as has been said by Lady Arden, I think, they are not restricted to reasonably foreseeable consequences relating specifically just to P. And that is the answer as to why the Act certainly does permit reasonably foreseeable consequences on people other than P. It's a matter of statutory construction. It's unarguable. And that's actually the answer. If you want a short answer, that's it. Because information relevant to a decision includes information about the reasonably foreseeable consequences. And if the consequences are that you might be prosecuted and you might be sent to prison or incarcerated in a mental hospital, or
for that matter, breach your neighbour duty to someone who you injure by your conduct.
Or you might become liable in tort. Yeah, foreseeably liable, or, I mean...
But in one sense, why does one have to go to section 3.4? Because in order to incorporate the Court of Appeals test, surely that's information relevant to the decision.
So the way it works is, my Lord is of course right, but the way that what the Court of Appeal have talked about, and I'll come to that, that's the golden thread. You need to look at this Act, look at section 3.4, and then there's a remoteness test, to use a tort and contract analogy, that if it's not the sort of thing that people, this is paragraph 80 in the Re-M case in 2014, if it's not the sort of thing that capacitated people commonly take into account on a daily basis when taking that decision, then it may be too remote. So I think in that case there was something about the prospect of the lady's fourth child being taken away and not having contact with it. That was thought to be too remote in deciding in relation to sex. And it certainly passes that test too. And I would just modify it to this extent. It wouldn't just be the considerations commonly taken into account by people of full capacity, but I would also add, or should be taken into account, because clearly, even if there was factual evidence that many people were committing rape, it wouldn't affect the correctness of the proposition that you should be taking the other person's consent into account. I know that's an unlikely sounding scenario, but it's not simply a question of factual observation, but there's a normative element to it. And I'd also like to draw the Court's attention at EF 225 to the Code of Practice, the Mental Capacity Act Code of Practice, cited in the Court of Appeal judgment at 22. So that's EF 225. And that's paragraph 4.19. which says as follows: if a decision could have serious, grave consequences, it is even more important that a person understands information relevant to the decision. That's it.
Is that a sliding scale of if the matter is trivial, you don't really have to understand the information? If the matter is serious, you do.
Well, I think
I just don't see where I find that in the Act.
No, the code is something you have to look at to interpret the Act,
right.
But clearly you need to interpret the Act. This is just what someone thinks the Act might mean. And indeed, in Aintree and James, the question before the Court was whether the code reflected the law. So that wasn't... The law comes first, the code is the code. I don't want to put too much weight on what the code says, but the code does happen to say that.
And the trouble with that is that capacity in this context is a binary question once you ask the correct question and have done the requisite training and assistance under section 1.3.
Indeed. Yeah. It's a binary question.
Do you support the proposition that there is a variation in the degree of understanding depending upon how serious the matter is? Or is it just the same test applied across the piece?
It goes to foreseeability of consequences. If you look at consequences, one element is how likely it is to happen. Another element is how serious is it, how significant is it? Yeah. And they both, you have to consider both when you're deciding whether it's something that needs to be considered in relation to a particular decision. But this is all very interesting theoretical discussion. The bottom line is, in sexual relations, you have to consider the other person's consent. This is not a grey area. The question raised by this particular case, on any view, because it has both seriousness and real prospect of occurring. And indeed, my clients think the way that JB has been able to have a relatively trouble-free time, and I say relatively, is because of the intensive supervision that we exercise on him a number of times each day. It's not just once in the day. My next point is that the Act is to be construed according to its terms, and reference to person-specific and act-specific terms, tests to the extent they've been relied upon by lower courts, do not find any support in the terms of the MCA. And I'd like to take you to EF 2920, which is the City of York case, which is Lord Justice McFarlane. And he says that the determination of capacity under MCA 2005 Part 1 is decision-specific. Some decisions, for example, agreeing to marry or consenting to divorce, are status or act-specific. Some other decisions, for example, whether people should have contact with a particular individual, may be person-specific. But all decisions fall to be evaluated within the straightforward and clear structure of MCA sections 1 to 3, which require the court to have regard to a matter requiring a decision. There's neither need nor justification for the plain words of the statute to be embellished. And this is, my submission is that that's exactly what the person-specific stroke act-specific concept does. It embellishes the plain words of the Mental Capacity Act with the intention of damping down or reducing the scope of relevant information in particular categories, one of which is the area of sexual relations, cuts off the otherwise reasonably foreseeable consequences and doesn't require you to look at the person in front of you.
Specifically, you're saying if it's construed as meaning consent to sexual relations must be consent to sexual relations in general, you are dispensed with any obligation to consider the position of the other person because you don't know who it is.
Well, indeed, you're not allowed to know. But it does two things, actually. It takes away, you're not allowed looking at the identity, but because there's reference to it being a very simple concept, somehow in the case law, courts haven't been willing to follow through with actually looking at what Section 3.4 requires, because it's supposedly act-specific, and that supposedly means that all you have to do is understand the nature of the test of pregnancy and STDs. So the argument in that case, actually, at 2916, and it will repay reading from between paragraphs 19 and 43, because it's the same concept that's being grappled with in this case, just to understand why sex and marriage have taken a different course to simply applying the statute.
That's City of York again.
Indeed, the argument at paragraph 20 is that the official solicitor in that case made was that whether an act-specific or person-specific approach is adopted, the same approach should apply across the board to all relevant domains, including marriage, consent to sex, care, contact and residence. Because at the moment what we've got is person-specific for contact, and we've got act-specific for marriage and sex. So you can easily have a situation where someone has capacity for marriage and sex, but they don't have capacity to see the person. So someone else has to take that decision on their behalf. So the argument being put is that makes no sense because they're so closely related, they should all be of one sort or the other. And at paragraph 30, the OS said there can be no warrant for adopting a person-specific approach to the assessment of capacity in one context but not in another. The contrary argument put was you just have to read the Act, paragraph 31. You don't find any reference to person-specific or act-specific in the Act. And that's what Lord Justice McFarlane said. Well, he actually accepted that some decisions may be status or act-specific and some other decisions may be person-specific. But in the same breath, he says, but all decisions, whatever their nature, fall to be evaluated within sections 1 to 3. And you shouldn't embellish the statute. I'm not quite sure how the two go together, because person-specific and act-specific do attempt to gloss the statute. And he expressly says that he doesn't agree that it would be absurd to fail to adopt either an act-specific or person-specific approach to each category of decision. And then he says something even more intriguing and tantalising. He endorses the argument that removing the specific factual context from some decisions leaves nothing for the evaluation of capacity to bite upon. But if you remove the identity of the other person when it comes to sexual relations, what are you left? You're just left with some very general things. So I think we can submit that most of the York case is right, but it's still leaving intact this historical existence of act-specific, person-specific, act-specific drawing a veil over the identity of the person. And at 43, the conclusion is what can be stated is the statute test is the same for both issues. The real question behind 3C is it permissible for a court to come to contrary conclusions on two matters? And then there was a finding on the facts. But my primary submission, though, is that you've got to construe the Act and not get caught up in act-specific or person-specific analyses which may not yield the results upon proper analysis that they're intended to yield, because it doesn't actually shed any light on what the answer is in a particular case if you call it person-specific or act-specific. The relevant information is still the relevant information.
In terms of intended consequences, are you going to come in due course to looking at the two recent first instance decisions that have been decided since the Court of Appeal's decision in JB?
So, I mean, the short answer to those is that in one of them, the lady could understand the concept of capacity consent with her current partner, and were it to be person-specific, then that would be fine. That's all she would be asking herself. Do I have capacity to have sex with my boyfriend? The answer is yes. And I think Mrs. Justice Gwyneth-Knowles found anyway that she had capacity all in all, and we can see why. And in the other case, the person simply couldn't understand consent, and the answer is education. And much has been made of the fact that this is some very significant change in the law, and it will affect a significant number of people. There's only been one case that's been put before this court where it's made a difference in over a year, because I think the decision was handed down last summer of the Court of Appeal, and it became very well known very quickly. And it's hard to see what the factual basis of a submission that this is going to be a game changer in terms of setting the level of sexual relations at a much higher level. As I say, of the two cases, one of them had capacity overall, and the other one didn't.
Can I just be sure what I've understood you to say? So as regards the HD case, although I think you told us that using the phrase person-specific is a gloss on the Act that one should perhaps try to avoid. I'm not sure whether that's the implication. You've just used that as the explanation. Now, do I take it that what you're really saying is that the ultimate question is about the decision and the specific decision being asked and the information that goes into that decision? That's the sort of overarching idea. Within that, it may well be that it becomes convenient to use labels like person-specific, but it is only within the overall idea that the Act is telling us to abide by. Is that what you're saying?
Well, what I'm essentially saying, you construe the Act. That's the only legal question you have to ask.
Yeah.
And the person, I'm sorry, I lapsed into that terminology because it's so universal, but really person-specific. My submission as to what person-specific means is you construe the Act. So you just apply the Act, reasonably foreseeable consequences, and if the decision involves another person, the focus of the decision is on that person and the consequences in relation to that person.
So the question is, does P have capacity to have sex with one or more unidentified people?
Yes.
Then it's not person-specific. But if the question is, does P have capacity to engage in sex with X? Well, then obviously it is, because it's part of the decision.
Exactly. And usually a sexual relations discussion will be in relation to a particular person, because you do conduct generally sex with particular people. So
that's eliding two things which are not, as what I understood my Lord to be saying. That, of course, you always have sex with a particular person, but it's what's the decision that the person is...
The decision is to have sex with a particular person. If there are particular risks posed by a particular person, it's hard to see if one person is likely to manipulate you and treat you very badly. If there's no perception at all of that.
It's an inevitable part of the prospective way in which the Court of Protection may be asked to work, that you may not know the identity of the person at the time when you're asked to decide the capacity question. Even though P will by the time he comes to make the decision.
Yes. So
the court can't do it on a person-specific basis, even though when it comes to it, P obviously will be.
All I would say is that contact, and we'll come to that, does require a person as part of the relevant information to work out the pros and cons of contact with a particular person. Yes. And it's hard to see why sex would be judged by a different standard.
Well, you can judge it generally. Somebody may have capacity generally to enter into sexual relationships with whomsoever they choose, if they understood that the other person had to consent.
Yes.
And
well, that's another potential level. And as I say, I'm not pressing the person-specific part as an essential part of my case at all. It's just simply a question that has arisen in the case law. It's It's a question you may or may not choose to deal with. But if it's being used to, the way it's been used in sexual relations cases, call it act-specific, to somehow suggest that consequences on the other party are therefore not part of relevant information. That's the relevance of it in terms of the appeal before the court today. That terminology can't be permitted to derogate from applying the Act and looking at the nature of the Act and the reasonable consequences.
And if there is a decision about marriage, does that also take into account the personality, potentially, of the person?
It doesn't at the moment, and I'm hesitating to suggest to the court that you should be changing the test for marriage. You'll need submissions on that. That's why I'm discussing it, but I'm not necessarily trying to make a strong submission one way or the other than you have to construe the Act. That's the job.
But I just wonder why, if you hold up the Act as the crucial test, you're allowing it to creep in relation to marriage, but not in relation to sex.
There's another big can of worms that you will come across, I think, at some point, which is that the Mental Capacity Act, when it came in, obviously has very general terms and it covers many areas, but there are various common law tests that existed beforehand.
What's common law got to do with it?
Well, one being, for instance, testamentary capacity. And the question is, I'm involved in the case that's arguing about whether the MTA should apply to testamentary capacity or not. And there is a 175-year-old rule, and in the Chancery Division that's taken very seriously the older it is. So there are a lot of arguments to be had about what the test is in particular areas, is all I would say. And marriage is in that category. You might think that all you do is you apply...
The Chancery rules, as you call them, are not set in stone.
No, I'm teasing.
And move with developments in psychiatric knowledge.
No, I know. No, but I think it has been approved by a number of Court of Appeals, for instance, that decision, so it needs serious consideration. So it's not quite as simple as... This is not an area where it's suggested you shouldn't apply the Act. But because the Act applies to the
understand how it is if a patient is proposing to marry somebody who will do them enormous harm, why you cannot take into account and consider the enormous harm that could be done by that person. I just can't grasp it at the moment.
Well, my lord, I'm not sure I have a good answer to it, but all I would say is there certainly are arguments in both directions, and I'm not eager to try and give you chapter and verse on that in this appeal.
But the converse is, if the patient is planning to marry a lovely person who's going to cherish and nurture them, does the fact that they wouldn't be able to distinguish between him and some horrible, vicious rogue mean that they can't get married?
Absolutely. I wouldn't want to suggest the answer right now.
But if you took into account the actual circumstances of that question,
yes,
you would be saying, well, the inability of the patient to distinguish between the two is irrelevant because the person is, in fact, perfectly okay.
Yes.
It's not going to do them any harm.
But if it's a question of capacity and they can't distinguish between a good person and a bad person, then...
But it's just the same as pregnancy. It drops out of the picture. If the person cannot conceive, well, there you are. It doesn't matter whether the person understands the risk or doesn't understand the risks of pregnancy, because the person isn't going to become pregnant.
Well, that depends if you can tailor it, and I'll make some submissions on tailoring in the MTA. So that's what the York case said. In the Riem case, which is one of the two Central Court of Appeal cases before the Court of Appeal case in this appeal, the Court of Appeal first approved the ruling in York about the MTA being decision-specific, and then set out general principles concerning the ascertainment of relevant information central to the determination of this appeal. And at EF 1497, the court said there had to be a practical limit on what needs to be envisaged as reasonably foreseeable consequences, such that the test should not become divorced from the actual decision-making process, carried out in regard on a daily basis by persons of full capacity to avoid inappropriate paternalism. And the official solicitor in that case supported the case, that test of what might be called remoteness at EF 1493. So there has to be a practical limit on reasonably foreseeable consequences. And at EF 1498-9, the particular application of that principle was that the difficulty of looking after a fourth child when she was already stretched, and the potential health risks to herself and to the fetus of pregnancy, and the foreseeable risk the baby might be taken away, and that she may or may not have contact with him, were too remote to constitute relevant information. In the B case, that's at EF 1046, that's the other very significant Court of Appeal case, judgment from the Master of the Rolls. At issue was an interim declaration, like in this case, that P lacked capacity to consent to sexual relations. The appellant challenged the inclusion of information relevant to the decision in relation to the risk of STDs, and that protection against such risk was provided by the use of condoms. And in that case, the Court of Appeal recognised that questions of mental capacity raised a conflict between two broad principles of social policy: the right of each individual to dignity and self-determination, and the protection imperative, that's at EF 1061. And the Court went on to note that what comprises relevant information has developed and become more comprehensive over time, that's at 47, EF 1063. And it observed that awareness of the choice was more than just a piece of relevant information, but was fundamental to having capacity. That's at paragraph 51, EF 1064. That's the only error we say in this Court of Appeal decision at paragraph 100, to simply include knowledge that there is a choice to consent or not as relevant information. It's actually more important than that. So following the principle in IM at 80, the Court of Appeal in B said at 57, that's 1065-6, that the risk of catching an STD through unprotected sex and the protection against infection provided by the use of a condom satisfy the requirement. These are facts well known among all sexually active generations. You could as well put in the question in this case: are they facts well known among all sexually active generations? Accordingly, we consider that in accordance with MCA sections 3(1) to 4, the ability to understand and retain these facts for at least a period of time, to either weigh them as part of a decision whether to engage in sexual intercourse, are essential to capacity to make a decision whether to have sexual intercourse. The Court of Appeal then went on to consider that it was no objection that many capacitated persons have unprotected sexual intercourse. And this is at 59. There is a fundamental and principal distinction between an unwise decision, which a person has the right to make, and decisions based on a lack of ability to understand and weigh up information relevant to a decision, including the foreseeable consequences of a decision. As the Code of Practice says, information about decisions the person has made based on a lack of understanding of risks or inability to weigh up the information can form part of a capacity assessment. So if you have a lack of understanding of risks, then that can form part of relevant information, particularly if someone repeatedly makes decisions that put themselves at risk or result in harm to them. The analogy with this case is clear. Now, significantly, the Supreme Court refused the official solicitor permission to appeal that decision. And although, there's some significance to be gained by that, they obviously, well, I don't know why they refused permission, but they did. Let's just leave it at that. And we say there's a clear analogy with knowledge that the other person must be capable of consenting and must consent throughout. If anything, the current case is a fortiori to the decision in B. The other person's ongoing consent is a more fundamental consideration than STIs and the ability of condoms to reduce transmission, because the potential harm to the other person is more serious, and to P, is more serious and immediate when there's lack of consent. Another instructive case is the RE-A case about social media. That's at EF 1401-2. And the relevant information was set out by Mr. Justice Cobb in that case as including subsection 6, paragraph 28(6). If you look at or share extremely rude or offensive images, messages or videos online, you may get into trouble with the police.
So what paragraph is it, sorry?
I'm sorry, that's 28, subsection 6.
Yep.
On page
EF 1402 to 1.
Thank you.
1401 to 2 even. And this is instructive because it's a case about capacity for social media. There is reference to potential criminal conduct at 28, subsection 6. And at 29, the judge explains at subsection 4, this is not intended to represent a statement of the criminal law, but is designed to reflect the importance which a capacitous person would understand of not searching for such material, as it may have criminal content, and or steering away from such material if accidentally encountered, rather than investigating further and or disseminating such material. In the Court of Appeal, in this case, the judgment comments on that RE case as follows at paragraph 59, which is EF 237, and the comments are instructive. The Court said it's instructed to contrast the information identified by Mr. Justice Cobb in RE as relevant information in relation to social media with the information which other judges have identified as relevant to the capacity to consent to sexual relations. There are 3 points. First of all, the information identified by Mr. Justice Cobb is more detailed and complex than the information identified by the case law in relation to sexual relations. Secondly, the relevant information identified includes, under factor 3, consideration of the impact of P's conduct on other people. And so going back to EF 1401 to 2, number 3 is if you place material images, including videos, on social media sites which are rude or offensive or share those images, other people might be upset or offended. That's information relevant to the decision on capacity in relation to sexual relations. And thirdly, the relevant information identified by Mr. Justice Cobb includes, under Fact 6, an understanding that P's conduct on social media could amount to a criminal offence. Now, turning back to the judgments in this case, Mrs. Justice Roberts accepted the principle in IM in relation to a reasonable limit on the information relevant to the decision, and that's at 39 at EF 274, penultimate sentence, but held at 81, and this is the single most critical paragraph in Her Ladyship's judgment in my submission, at EF 284, that these risks were divorced from everyday decision-making by capacitated people. Whilst the ability to use and weigh information remains relevant to a capacity assessment in the domain of sexual activity, it should not involve a refined or nuanced analysis which would not typically inform any decision to consent to sexual relations made by a fully capacitous individual.
I'm sorry, I do apologise. What paragraph number?
That's 81, my Lord, at EF 284.
Thank you.
To require him to demonstrate as an aspect of his fundamental capacity in this context a full appreciation, and this could be the reason for the error because Her Ladyship thought it was some sort of very complex concept, of both his own and a partner's initial and ongoing consent throughout the course of that sexual activity would be to impose on him a burden which a capacitous individual may not share and may well be unlikely to discharge. We say that's wrong. The Court of Appeal also thought that was wrong. That's at EF 249 to 50, paragraph 94. The information relevant to the decision, I think I've shown the Court this, inevitably includes the fact that any person with whom P engages in sexual activity must be able to consent to such activity and does in fact consent to it. Sexual relations between human beings are mutually consensual. One of the many features that makes us unique, a person that does not understand that sexual relations must only take place when and only for as long as the other person is consenting is unable to understand a fundamental part of the information relevant to the decision whether or not to engage in such relations. And at 99, the Court recognised that what comprises relevant information has developed and become more comprehensive, and that development has continued in this case. The Court in IM stressed that the notional process shouldn't involve a refined analysis of the sort which doesn't typically inform the decision to consent made by a person of full capacity, but as already stated, and this is the important part of 99, the information which a capacitous individual must take into account in deciding whether to engage in sexual relations includes whether or not the other person is consenting. And I've already taken the court, I think, to the fallacy, the visceral fallacy, that although there is a significant visceral element in the decision, that doesn't mean there isn't a significant cognitive element. And at 96 EF 248, the court says that it's never been suggested these decisions are exclusively visceral or instinctive. It involves thought as well as instinct, and amongst the matters which every person engaging in sexual relations must think about is whether the other person is consenting. Now, the next topic is protection of the public. The argument put by the appellant is that the MCA does not have as one of its purposes the protection of the public. And my submission is that that's an inappropriate submission not raised by the facts of this case. On these facts, the restrictions on contact, which are the primary means of preventing harm in this case, are intended to protect JB from potential prosecution and or harmful action by third parties aggrieved at his acts. It's therefore a false dichotomy to attempt to portray the decision as here one that was implicitly solely for the protection of the public, because it's equally for the protection of P. As Mrs. Justice Leven said in the SR case, and you'll find that at EF 1193, and that was a case in which deprivation of liberty was authorised in respect of SR, who lacked capacity in relation to care, where avoiding committing another offence was strongly in SR's best interest as well as being for public protection. The care plan was to keep him out of mischief and therefore out of psychiatric hospital. And you'll find that at EF 1193, and the particular quotation at 41 is at EF 1201. And at 41, the judge said, in the case of SR, it might be argued that the purpose of the deprivation of liberty and some of the other elements of the care package is the protection of the public rather than the care of SR. However, for the reasons given by Mr. Justice Moore in ZZ, I think this is a false dichotomy. It is strongly in SR's best interest not to commit a further offence or to place himself at risk of recall under the MHA Mental Health Act 1983 if the Secretary of State were to conclude that the risk of other offences was too great. In those circumstances, the provision of the care plan in terms of supervision and ultimately deprivation of liberty is, as Mr. Justice Moore put it, to keep him out of mischief and thereby assist in keeping him out of psychiatric hospital. This is strongly in his best interest as well as being important for reasons of public protection. Now, this is a decision on best interests rather than on capacity. So it's only if someone lacks capacity do you then turn to Section 4, which I haven't shown the court, which explicitly includes all of the circumstances in considerations. But the real point is that this is not a case where the restrictions are simply solely for the protection of the public. They're equally for the protection of P, and it can't possibly be argued, and I don't think is argued, that the purpose of the MCA can't encompass the protection of P. There are a couple of other cases that are relevant on this. The ZZ case that was referred to, I think it's Authority 34, EF 1646, which is, and also EF 1657, and then also the Skripal case, which is Authority 33, EF 1627, and that's probably worth a quick look. This is again on the topic of the relevance of the MCA to individuals other than P. Now, that was a case involving the Salisbury poisoning victims. That's at 1627. A man and his daughter were unconscious and under heavy sedation in hospital. Porton Down concluded they'd been exposed to a nerve agent. The government issued a formal invitation to the Director General of the Organisation for the Prohibition of Chemical Weapons, sent some experts to verify independently the analysis. They needed to take fresh blood samples and have medical notes disclosed to them. The treating NHS trust required a court order would be needed to authorise these steps, and applications were made by the Secretary of State. And over the page, top of 1628, holding 4, the courts had emphasised in a variety of contexts that best interest or welfare can be a very broad concept, and the Lord Chancellor's Code of Practice also identified the possibility that other factors that the person lacking capacity might consider if they were able to include the effect of the decision on other people, the duties of a responsible citizen. And if we can pick that up at 1641 to 1642, paragraphs 24 to 25, there is reference, for instance, at subsection 4 to the re-GTJ test. The word interest in best interest doesn't confine the court to considering the self-interest of P. Further, the wishes that P would have formed if P had capacity, which may be altruistic wishes, can be a relevant factor. And in Aintree, Supreme Court noted that there could be benefits other than direct benefits to the patient. And at 25, the Lord Chancellor's Code of Practice referred to the possibility that other factors the person lacking capacity might consider, if they were able, could include the effect of the decision on other people and the duties of a responsible citizen. And it was on that basis that the blood samples were authorised, because of the views of a responsible citizen. We can see that at 31, 1643. Most reasonable citizens have quite an acute sense of justice and injustice. Most want to secure the best information about what would have happened when a serious crime is alleged to have been committed. They believe in the rule of law, and they would effectively want the OPCW to find the answer. So that is an example where the interests of others was found to be explicitly relevant to what was in P's best interests. And there's also another reference to Aintree, which I won't take the court to, but it is a Supreme Court case in this very area. I'll give you the reference. It's tab 55, paragraph 24, EF 2104, where Baroness Hale, talking about best interests, says it might include altruistic sentiments and concern for others.
I'm sorry, could you give me that page number again?
Yes, my lord, yes, it's EF 2104.
Thank you.
And it's paragraph 24. So just making some general submissions about the purpose of the Act. The first submission which I've made is that in reality this isn't a case about public protection per se. There is protection of P with a parallel effect of protection of the public. And that's the answer to the you can't take the protection of the public into account. Well, when it overlaps with the protection of P, you certainly can on any view. But there is a wider point, which is that there is nothing in the Act that delimits the considerations that may be taken into account, either in relation to capacity or best interests. Construing the Act, again, which seems to be somewhat old-fashioned these days, certainly at first instance, on what basis could you argue, as a matter of public law, that one of the purposes of the Act is not public interest? Indeed, Bennion, which is Authority 21, that's EF 121, EF 4441, Section 26.2 says as follows: it is a basic principle of legal policy that law should serve the public interest. The Court, when considering in relation to the facts of the incident case which of the opposing constructions of the enactment would give effect to the legislative intention, should presume that the legislator intended to observe this principle. It should therefore strive to avoid adopting a construction which is in any way adverse to the public interest. It's a general presumption that statutes serve the public interest. So actually the burden is on the appellant to show why this statute does not follow the general rule that statutes are for the public interest. And there is nothing in the statute that could possibly suggest that. Thirdly, the legislation must be construed in accordance with the Human Rights Act, pursuant to Section 3, so far as possible. Words implied must go with the grain of the legislation. That's the Gaidan and Godin-Mendoza case, Authority 119 EF 4338, paragraph 33, per Lord Nichols. There is no difficulty in construing the MCA. It doesn't go against the grain of any part of it, so as to permit the state to comply with its positive obligations to protect the public under Articles 3 and 8. Section 27, this is my next point, is to do with the tail wagging the dog. That's what Section 27, I fear, may have done in my submission. I'm not just fearing it, I'm submitting that's the effect of Section 27 on the level of the test that first instance judges in particular have alighted upon. So Section 27, and that's EF 868, prohibits the decision maker from consenting to have sexual relations on behalf of a person. But simply because a court or another decision maker may not make a decision to consent to sexual relations on behalf of P cannot mean that the test should be set artificially low so as to ignore fundamental aspects of the nature and character of the Act or of the reasonably foreseeable consequences. The clear terms of Section 3 of the MCA do not permit such an interpretation, and it would reduce reduced levels of protection both for P and for others in relation to risks which P cannot foresee if somehow the fact that if you fail the capacity test, the fact you can't then have sex affects the level at which foreseeable consequences are judged. The motivation to set a low bar appears to underlie the reasoning of many of the first instance judges. Many of the cases also appear erroneously to regard previous cases as purporting to summarise all of the information relevant to the decision to have sexual relations, ignoring the fact that later cases raised different issues which hadn't been ruled upon in previous cases. And the Court of Appeal in B, in the local authority, said that different cases have recognised different factors to constitute relevant information. The next subject is tailoring of relevant information. I've already given the Court, I think, reference to paragraph 3.16 at EF 1798 of the Law Commission report, which says that relevant information applies to every case. We can turn to the Court of Appeal decision in this case at 70 to 75, which is EF 241. I wonder if the Court would mind just reading those 2 pages down to 75.
Is that 71 to 75 or 70?
It's 70 to 75. The official solicitor now argued that a tailored approach in application of each element of the test was logical and permissible and reflects the reality of relationships. And I should say the Court of Appeal ducked this question because it wasn't raised on the facts, and you may choose to do the same. So the position is that the information relevant to the decision, according to B and a local authority, and you see that at 242 at the end of 72 in this decision, is that the individual tests are to be regarded as guidance to be expanded or contracted to the facts of the individual case. And this is the information relevant to the decision under section 3 that we're talking about, that apparently now, after B, can actually be expanded or contracted or tailored. The first problem with that is that if we are persisting, and I apologise in advance for using this terminology, with an act-specific test that doesn't pay regard to who the other person is, you can't possibly tailor it based on who the other person is. It logically doesn't work. So if you're adopting the Mundy test of you're not allowed asking who the other person is just because the other person is postmenopausal or or your long-standing partner of 25 years, so there's no real risk of an STI, you can't actually do that if it's an act-specific test. It would have to be person-specific. You'd have to allow in the identity of the other person in order for that to be something that wouldn't be relevant. Secondly, the Law Commission has said that information relevant to the decision is relevant in every case. And thirdly, that's what the statute, there's no indication in the statute that relevant information is some sort of discretionary choice at the instance of the judge. And if it was only the judge that could rule on a particular case, does that mean that every case would have to come to court in order to be tailored? So my submission is that one has to be very cautious in terms of tailoring. That obviously doesn't apply when you're talking about gay sex, because the risk of pregnancy in gay sex obviously doesn't exist. There are very clear-cut cases where it doesn't apply at all. But that's the nature of the activity itself, rather than the identity of the particular person. But to reduce the statute to, under Section 3, the answers of the inquiry under Section 3 to no more than guidance to be expanded or contracted the facts of the individual cases is not the answer.
But are there any other person-specific decisions other than contact? Because contact, obviously, it's never going to be the fact that somebody doesn't have capacity to choose to have contact with anybody, because everybody wants to have contact with somebody. But are there any other kinds of decisions which fall into that person's specific class?
Well, you have to look at activities that are done with other people. So contact is the main one. Contact covers a huge range of situations. And for contact to be person-specific and for sex not to be, creates an impossible tension. And that's the solution isn't to delete parts of relevant information. I'm sure that's not answering the ladies.
I thought you said that contact is a person-specific.
Contact is a person-specific.
And sex is not a...
And sex is not. That's
right.
exactly... That's
so
exactly.
Why are you saying that creates an impossible tension?
Well, the inconsistency between the test for contact and the test for sex creates great difficulties in working out what a person is able to do and what a person is not able to do.
Right, but are there other kinds of decisions, like contact, which are dealt with by the court on a person-specific basis? So the court decides you can have contact with X but not with Y. Are there any other kinds of activities which are limited in that way? Because clearly marriage and sex are not limited in that way.
My lady, my submission is that most decisions are, when they involve another person, person-specific. It's just sex and marriage that are not.
Well, but looking at financial matters, you would decide that someone is not financially competent. You don't decide...
But that doesn't involve another person. That involves an investment decision or consequences of putting your money in a particular place.
Right.
Contact is the concept that the court uses to encapsulate people's contact with other people. And that's It's just very strange that the law would require that to be, and I'll take court to the test for that in B. One of the requirements is that you be able to weigh up the pros and cons of contact with a particular person.
Just a bit puzzled by this submission, because you're effectively saying to us that we shouldn't be tailoring the information, as I understand it.
Well, you can if it's gay sex, because pregnancy isn't relevant.
Yeah, so
in a very limited way.
But your basic proposition is that one should steer clear of tailoring.
That's the basic proposition,
Yeah.
yes.
And yet I'm then left in this area with problems like the case of re-HD, which seemed to me to be one, in order to make the test that you want us to accept workable, you would need to tailor the information.
No, you don't. In HD, if it's person-specific, if you're allowed to take account of the identity of the partner, then she has capacity in relation to her partner. There isn't a problem. She doesn't have to think about other...
Yeah, it sounds to me you're tailoring at just a different stage in the inquiry.
Well, you can call it... what I mean is cutting particular pieces of relevant information out because the judge says, I don't think it matters in this case.
But is that because of the nature of the decision that you're looking at? I share my Lord Borough's slight puzzlement about...
I mean, at some stage you are tailoring because you are asking information about a specific decision.
Yes.
And that specific decision can be tailored in relation to a particular person.
There are two meanings of tailoring. I think if you're focusing on a different type of decision, the difference in HD would be, do I have capacity to consent to my partner?
Yeah.
Then you're looking at a different decision. And I'm not calling that tailoring.
Okay.
I'm calling that's fine, that's legit, that's applying the statute. Whereas tailoring would be like in NB to say that even though you can't look at the identity of the partner, because this couple has been together a long time and we don't think there is any infidelity, the woman doesn't need to understand the risk of STIs, because there isn't a risk of STIs with this partner. And you just can't have...
That's tailoring, isn't it?
Well, that is tailoring, and I don't think you can do that sort of thing if you're not allowed to look at the identity of the partner.
What your basic proposition was you were able to...
Well, I think you are, but Mr. Justice Hayden, in that case, is one of the adherents to the Act-specific test. And under the Act-specific test...
What is your submission that the law is?
The law is you need to first look at the decision. The decision to have sex is fundamentally in relation to a particular partner. One doesn't decide to have sex in general. One decides to have sex.
Not if you're having to look at it prospectively.
Well, contact is also looked at prospectively.
Well, quite, but in this context...
And that's in a particular, with a particular person.
But in this context, the question is whether he should be permitted under the care regime. I know we're not answering that question, but ultimately the question is whether he should be permitted under his care regime to come into contact with persons with whom he might well develop a sexual relationship. And that has, it's inherently prospective. I mean, otherwise you have a chicken and egg problem. It's
it wouldn't necessarily require a particular person, but the significance of that is to work out the relevant information, you do look at the nature of that, the foreseeable consequences, and consent the other person is required. But then, if there was a particular partner involved that didn't have a particular risk, it may be, if the court were permitted to look at person-specific tests. So there are two situations. There's the general scenario where there isn't a particular partner in mind, and you can't tailor in that situation because you just have to apply the Act. But if there's a particular situation, that would give the flexibility. The courts are clearly itching to try and develop such that there wasn't a particular risk in a particular case. But that's only when there is a particular person in mind.
It depends on the question, the matter.
Indeed, and the decision might be
consistent. It has to be made, which dictates the information about the decision, and that information may vary from case to case. And I just don't understand why it is that you anticipate that there has to be, that this will suddenly increase the workload of the court, because people will not be able to make the decision. you said that would every case come to court in order to be tailored? Well, doesn't it stand to reason that if the matter is a sexual relationship with a person who cannot conceive, that you don't need to come to court in order to understand that that part of it falls out of the equation?
I think Mr. Justice Hayden's proposition in NB was that a judge could tailor the information. If only a judge could do it, then cases would have to come to court.
And which part of the statutory scheme do you refer to? What is the trigger for coming to court?
The trigger from coming to court under the NHS and Y case in the Supreme Court in 2018 is where there's a dispute. And in that case, it was a dispute over best interest, but it could be a dispute over capacity.
Yeah, well, so
if there's no dispute, you don't have to come to court. That's basically what it means.
Well, in a case where somebody has capacity, apart from they don't understand this concept of pregnancy, and the person they're proposing to have a sexual relationship can't conceive, there's no dispute.
There is some uncertainty, though, about whose word goes, and that isn't a desirable aspect in this area, because one decision maker may take one decision, another decision maker may choose to not tailor it. And the minute you stop applying the statute expressly, there can be problems. I mean, it doesn't arise on the facts of this case, and the Court of Appeal described it and then ran away from it. And there can be advantages to doing that.
Well, they listed out in paragraph 100 the factors that may be relevant.
Well, they said maybe, because they were respecting what the Court of Appeal in B had said about no more than guidance. But I'm submitting that isn't a reading that one gets readily from the statute.
Well, the statute brings you to the matter about which the decision is made, and then you have to work out what the information is.
You do, but there must be consistency in these decisions.
But a decision, even final, that the appellant in this case doesn't have capacity to engage in the way he would wish in sexual relations, would or would not rule out him coming back, or if there's a dispute, the parties coming back.
He could come back any time.
No, to come back at a later stage to say, well, OK, we're not trying to undermine that, but he has now, despite our best endeavours, formed a relationship with a particular person, and they both want to make that a sexual relationship. It would then become a person-specific question about capacity, wouldn't it? Because it would be whether to have a sexual relationship with that named person,
in theory,
having all
yes.
the characteristics that the evidence might develop about that person, including that person's consent.
In theory, yes, but the Court of Appeal in this case said that the reason they weren't going to deal with the tailoring issue is the other person's consent could never be tailored. A matter of policy, that could never be, that's a fixed piece of relevant information regardless of who the other person is.
The other person might consent. I can see difficulties about maintaining consent, but the other person might consent. Yeah. And,
well, quite, because they're in a relationship doesn't necessarily mean she's consenting all the time.
No, depending on, people must, as a matter of public policy, people must have the right to change their minds in these situations. Yeah. And that's why it wasn't raised by the facts of this case, because you can have different types of relevant information like pregnancy that might not be relevant at various times, or the STI point, which is more difficult. But whatever the argument on tailoring is, it can't possibly, as a matter of public policy, apply to the requirement for consent.
Well, it can't remove it altogether.
No.
But it may affect the depth of understanding or whatever that the patient, that P, would have to have.
And that's the HD point.
I mean, that's a tailoring point, I think.
My Lord, yes, that's the HD. The answer to HD is that she could conceive of the consent point in relation to the person in front of her. And on that basis, if it was that more particular question, you could see more readily how she would pass the test.
Yeah,
but you're divorcing it from the actual people involved, because some people who suffer from these unfortunate conditions are completely compliant. They have been brought up in a way where they obey instructions and some people are aggressive and not compliant. Okay? So if you have somebody who's completely compliant and is likely to actually obey an instruction, why should they be deprived of sex? If you were convinced, not convinced, on the balance of probabilities, that any instruction given by the other person to the patient would be obeyed, why is it that they should be deprived of sexual intercourse?
Because if they then, I don't think the law would readily recognise that somebody could agree to sex regardless of the conditions as a matter of policy. I mean, there are various ways in which you can engage in sex, some of which are, let's say, more violent than others. And
I'm looking at the completely compliant person. Absolutely. Put it at the highest you possibly can. Guarantee they're going to comply.
I promise I will consent to sex with you under any circumstances.
No. I promise I will comply with your instructions.
Right.
Under any circumstances whatsoever. And demonstrated that over a lifetime.
And who is it whose capacity is in issue?
The patient, who has demonstrated over a lifetime that they're compliant.
But they need to understand that the other person must consent.
Yes, but the other person will say, by the way, stop, and they're compliant.
Well, then they must understand.
Yeah.
Well, I mean, if they stop, then they understand.
They understand the word no, that's right. Yeah.
But they must understand consent in order for that situation to work. I mean, anyway, it is quite difficult to answer specific factual scenarios without the evidence.
It is.
And I'm not trying to get out of the question,
no.
And it's not an easy question to answer.
Yeah.
But my general submission is that whatever the whys and wherefores of tailoring, and I've made my submissions in relation to that in general, this court doesn't need to deal with it because, as a matter of public policy, the consent of the other person can't be tailored.
Yeah.
Regardless of the identity of the other person.
There is some reference in the submissions to the case of C and whether there can be provision to allow P to have sex with a sex worker. You may say even that doesn't entirely rule out the question of consent.
They must be entitled to change their mind in relation to consent, is the answer to that. I mean, I agree, the odds are better that they're going to continue to consent, but they must be permitted, as a matter of public policy, to withdraw their consent. It's a matter of protecting their own bodily integrity and their Article 8 rights. So just to finish up on that, just seen the time. Person-specific test, I think I've made my submissions on. All I would say is that the Supreme Court refused permission in IM on that, and it was the main point in that case, saying this is definitely a point of general public importance, but it's not raised on the facts of that case, and the same may be true here. Just briefly addressing the criminal point, I do have probably an hour and a half submissions on that, which I'm not going to get a chance to give. The bottom line is that the RAG case stating that the difference in definition of capacity, this is at 1389, paragraph 25, in the civil and criminal jurisprudence is a difference without a distinction, is wrong. There were inadequate submissions in that case, even in MB and MM. Mr. Justice Munby recognised that the risk of STDs and pregnancy were part of the civil test. That's never been part of the criminal test. Nor could they be in REM. It's a forward-looking act-specific test. In capacity, it's person-specific and retrospective, looking at criminal. Rook and Ward, EF 1806, paragraph 1.234, state, when considering authorities in this context, it's important to acknowledge the difference of approach between the Court of Protection and the criminal courts. That's it. Practitioner, that's the leading practitioner text on sexual offences. Baroness Hale in Cooper at EF 1443, paragraph 25, held that the relevant definition in the Sexual Offences Act was the statutory definition and not the common law definition. That implicitly recognises that they're not the same. She then doubted the common law definition. And they clearly aren't the same. Capacity in the MCA is defined in section 2. The Sexual Offences Act contains offences at sections 1 to 4. That's EF 871 to 4. So it's, and there's a reasonable belief defence. Whether a belief is reasonable has to turn on all the circumstances. Section 74 defines consent, and a person consents if he agrees by choice and has the freedom and capacity to make that choice, but capacity is not defined. That's EF 894, section 74. And it's impossible to imagine that capacity in section 74 of the Sexual Offences Act is automatically to be glued to the definition in the MCA. It would require express reference to that. And that's the OS's submission, that the JB case has raised the criminal test so that more people will be prosecuted as a result of the Court of Appeal in this case. The Law Commission expressly recognised, the Law Commission actually had the answer, I think back in 2000, when they said that the considerations relating to capacity in the civil law and those in the criminal law were not the same. That's our skeleton appendix at 22 to 26, especially at 22. That's EF 4529 to 4532. The JB decision is cited in Blackstone's criminal practice at B332 EF 1792. There's no suggestion that it's affected the criminal test for capacity. Closer to the mark is the observation of Mr. Justice Headley in H, that is at EF 957, stating that it's of course highly desirable that there be no unnecessary consistency between capacity in civil and criminal law. That's EF 962 at paragraph 22. So they don't have to be the same, but there shouldn't be any unnecessary consistency. And the submission that the discretion on the police or national crime agency to apply for sexual risk orders or sexual harm prevention orders is relevant to somehow to the test for capacity in relation to the MTA has no statutory basis. And if it's actually true that the MTA must not be concerned with protection of the public from sexual offences, does that really mean, per Lord Stevens, that we throw people like JB on the mercy of the criminal justice system? Is that really the only solution? And its dubious final point on that is that Rook and Ward say, in relation to SHPOs at EF 1834, that SHPOs shouldn't be made where the offender's mental impairment is such that he's incapable of understanding or complying with its terms. And if you don't understand, stay away from this person. In civil law, because he lacks capacity for contact, how is this order going to be at all useful? And I know I'm overrunning 1 minute on human rights, if I may. There are Article 8 duties and Article 3 duties on the public authority to protect people in IC in Romania, for instance, EF 1744 at 51 to 52. We have to take measures designed to ensure that individuals are not subjected to ill treatment, including administered by private individuals, providing effective protection, including of children and other vulnerable persons, to prevent ill treatment of which the authorities had or should have had knowledge.
I think we have this in your
yes, my Lord, I mean, you have my submissions on that. The bottom line is that...
We won't ignore it just because you haven't had time to repeat it.
You just do need to be aware of this Court's decision at SC and the approach to justification in that case from last week that we have included. So basically, there's a wide margin of appreciation where there isn't a consensus among member states, and also that there are sensitive moral or legal issues. That's Evans in the United Kingdom, EF 4112, paragraph 77, and similar factors were relied upon in SC. That's this Court's decision last week at 115, and that's at EF 99 in the supplemental bundle. I think I have indulged your invitation a bit too long, so unless there's anything further, my Lord, those are my submissions.
Thank you very much indeed. Yes, Mr. McKendrick. I'm sorry, you got slightly shortchanged, but only by a few
Fine,
pennies.
I don't have very many points, so we'll finish before 4. I think I have 6 points. Point 1, just recapping on the York case, Lord Justice McFarlane, which is in the bundle at 2921. Well, it begins at 2920, paragraph 37, where Lord Justice McFarlane says the court is charged in section 2.1 in relation to a matter with evaluating an individual's capacity to make a decision for himself in relation to the matter. No need has been identified for grouping categories of matter or decisions into domains, save where to do so has been established by common law or by express terms of the 2005 Act, for example, capacity to marry. You've heard my submission in respect of sections 2 and 3 and what is the matter in the decision, which I won't repeat, but that does provide some support that the pre-existing common law position and also the express terms of the 2005 Act, from which I'm inferring Lord Justice McFarlane takes that from section 27. The second point is whatever way my ladies, my lords, decide to determine what is the section 2 matter and decision, whether it's to consent to or engage in, our respectful submission is that there should be one test, because 2 tests is likely to create confusion. It's unnecessary, invasive of P's rights to be tested against 2 different tests in this very difficult area, and is not warranted, we say, from the languages of sections 2 and 3 of the Act. If the court concludes that the appropriate decision is a decision to engage and not to consent, contrary to our submissions, we would submit that that is a decision which is prohibited from a best interest decision as per the list at section 27.
That seems to be common ground.
My Lord, yes. In terms of the discussion between my Lord, Lord Burrows and Mr Sachdeva regarding paragraph 106 of the Court of Appeal's decision, and must be able to consent as an alternative formulation, again, that's contrary to our principal position, but we would say that is a more appropriate level of test, because the case, which I don't think we've had much time to look at, of HD, Mr Justice Cobb's decision, at 1456, I just asked my lords, my ladies, 1456 to read paragraphs 26 and 27. You can see that the expert, Dr. Carrot Baker, the evidence which Mr Justice Cobb accepted at paragraph 26 was that HD, he did not think that HD would be able to achieve an understanding of the need to assess the capacity of a sexual partner's decision to engage in and consent to sexual relations. It is beyond her ability. It wasn't just prospective or hypothetical partners. The abstract concept of her own partner's capacity was a very difficult one, and we say that's certainly too high a test. In response to my Lady Arden's point regarding Article 8, I may not have the complete or full answer, but there are 2 parts to the Article 8 positive duty on the state, which I understand to some extent was the premise of the question. One is found in the protective obligations exercised through contact restrictions, and one can see that most clearly in the decision of Mr Justice Baker in TZ number 2 at page 981. paragraph, sorry, just find it, that I rely on, is at paragraphs, there's really no need to read it now, but it's paragraphs 46 to 48, where essentially Mr. Justice Baker is trying to balance the fact that TZ has capacity to consent to sexual relations, but lacks capacity in respect of contact and was at risk of others. So that there is a mechanism for contact decision-making which can protect others, whilst at the same time is respecting someone's capacity to consent to sexual relations, which doesn't involve an understanding of their partner's consent. And a small further point, we rely on the positive duty in respect of the state in our argument regarding the application of the sexual risk orders. And at page 3428 of the bundle, you will have something called the Antisocial Behaviour, Crime and Policing Bill, European Convention on Human Rights Supplemental Memorandum by the Home Office. And paragraph 12 is the relevant paragraph where there's reference to Stubbings in the UK and Adams in the UK, and the Article 8 duties, and really that's reasoning the purpose behind these protective measures like SROs.
You just give me a page number for that.
My Lord, yes, of course, 3430.
Thank you.
And our case references that in writing at paragraph 71 on electric bundle number 91. The fifth and small point is on public protection. Our case is the MCA has no role whatsoever in public protection. Our case is that the identification of the relevant information in section 3 to inform the matter in section 2 cannot be carried out with the aim of public protection issues. The three cases that I referred to at the beginning of the day, Mr. Sachdeva recently referred to, are all best interests matters 2 on.
Well, he, of course, says it's not a question of public protection. At the end of the day, you are indirectly helping P. You're deciding something is not in P's interests.
Well, again, that comes back to what is the framing of the relevant question. If it is, as we say, P providing consent for themselves, then that's respecting and promoting their autonomy. Mm-hmm. There are other mechanisms to protect others in other circumstances. And the sixth and small point is on the criminal test, what amounts to the reasonably foreseeable information for someone to have capacity. It's suggested that STIs and pregnancy don't form part of that test. At the supplementary bundle, which I only have in hard copy, I'm afraid, at D35, there's an excerpt from Rook and Ward on sexual offences at paragraph 7.69, which suggests that under the 2003 Act, we suggest that strict logic phrase, reasonable foreseeable consequences, does refer to the complainant's understanding that the sexual activity could have implications for his or her sexual health, and in the case of a woman could lead to pregnancy. My Lord, that is it from me, unless I can assist any further.
Oh, well done, Mr. McKenzie. Thank you both, and all the significant teams of silent people behind you who have contributed to the submissions made today. We've been greatly assisted by all of them, and will now take time to consider our judgment on this important case, and we'll make it available as soon as we reasonably can. Although, of course, I'm sure you appreciate that the long vacation is fast approaching. Do we know when the judge is currently listed to deal with the fact-finding?
Monday. We have a further hearing on Monday before Mrs. Justice Roberts. I don't know the exact scope of the issues, but I will find them out tomorrow morning. Well, I'm afraid you
won't have our judgment by then.
That would be a minor miracle.
Yes.
Not such a minor one.
Thank you very much.
Thank you, Lord.